what would the tax consequences in percentage be?
So it would have. I think he would have had a pretty big gain. So he would have been paying about 15% federal, and then 8 to 10% California, and then so it was
25%.
So it was pretty big. And then I just kind of gave him a few different options. He just didn't bite at any of it. So.
Well, yeah, I mean, because he did email me. He's like, "Hey, I think we're just going to hang on to it for now." But my question, like when I'm working with people like that, because is at time of death,
yes,
do his heirs not pay taxes on it?
That's right, and so that's what we talked about. So it's because he's held that for so long, he's essentially depreciated all of his tax basis. So it's zero. So anything he sells it for, it's pure capital gain. And then, so the best thing to do is, unfortunately, I was kind of joking about this with him yesterday. It's the only way to avoid tax is to die, and die and pass on your assets. And because when that happens, your kids take a stepped up tax basis to fair market value.
Or sell it.
Yeah. So so then you just sell it right then, and there's no capital gain to be recognized.
So even though it's in an LLC, so what if one of the, because it's husband and wife, they both have to pass? I mean, because it's
so technically, yes, they would both have to pass. So because it's this, I guess that's the interesting part. I didn't know it was an LLC tree as a partnership.
Yeah.
So in California, because you have community property, when one spouse dies, it's a double step up. So it only takes one spouse to die, but then she would have to sell the partnership interest, or she would have to liquidate the LLC thereafter, and then take a step up basis through that liquidation process. So it would have been, she could have done it, but it's been a little bit more complicated.
What about if you put it into Irrevocable Trust and then sold it that way and then drew off of it?
So that's something we talked about as well. So the Irrevocable Trust takes the same tax basis that he had, sell it, and then so the Irrevocable Trust pays the tax, and then essentially he could take distributions out. But there's this thing, have you heard of a structured installment sale or a deferred sales trust? So essentially, I talked about this with him as well. You bring in a third party fiduciary. It's kind of like a 1031. They come in, they're actually going to be the purchaser or the seller of the property, take the sale proceeds.
So this is your slides?
Yes.
Okay, perfect. Okay. Well, thank you guys all for coming and attending. I'm Sean Radcliffe with Radcliffe Associates here at Coldwell Banker. Alton Moore has come today to talk to us about living trust and pros and cons, and mostly pros. One of the things that Radcliffe Associates we like to do is give back to our community to make sure that we're giving you guys every piece of knowledge that you have. We also do some fun events. So one of the things that I wanted to bring to your attention is that not this Saturday, but Saturday the 26th at 9 a.m. to 12 p.m. we're doing a pet adoption with Priceless Pets, and They're a no-kill organization, so we're going to have crepes, coffee, and cuddles on Saturday morning. So you guys feel free to come by, or at least pass this along to people that are interested in adopting dogs. That would be super helpful. They have a lot of amazing dogs, and you can follow them on social media as well. March 5th, we're doing our free movie night in the park over at the Friends campus off of Rose Drive. So we're going to be showing Moana. I've only seen Moana 18 times this week at my house. But one of the things is it's underneath the stars. We bring a big 40-foot screen, and we have hot dogs and popcorn and candy. And it's just a great family event. And once again, that's a free event as well. There's an Eventbrite link, flyers up here. It's also on our YouTube, social media, and all different areas there. So,
welcome.
Yeah, so hopefully you guys can join us for that. And of course, at any time during the presentation, feel free to jump up here. We have Chardonnay, Cabernet, Pinot Noir, Sauvignon Blanc, and Charcuterie. So one of the reasons that we brought Alton is because not only is he trust, well, you have your law degree, but you also are a CPA. So one of the times that we see is that we have a lot of people that can refer and do trusts, but they can't tell you the tax consequences. So he's kind of like the perfect package all rolled up into one. So Alton, I'll let you take it away.
Thank you, Sean.
Yeah.
Nice to see everybody tonight. How are you guys doing?
Good.
Oh, all right. So Sean mentioned my name's Alton Moore. I'm an attorney and a CPA. Primarily my practice is tax, but I also do trust and estate planning, and I do business organization. And so I will say this. I don't know everything. So like if you guys have a question, I can't figure it out, I can definitely point you in the right direction. But I can't help you in a lot of things with tax, trust and estate, and business organizations. But tonight we're going to be talking specifically about trusts and why you should use them and kind of some of the pitfalls of what happens when you don't. Really, what I want you guys to take away at the end of this presentation is probably like a high level talking points about what trusts are, what their benefits are, and you're not going to know everything, right? It's impossible to cover everything, but we're just going to get kind of a general overview. I will say, as I start to get into this, sometimes I tend to rapid fire, so feel free to raise your hand, slow me down, ask me a question. Don't be afraid. I'll probably ask you guys a few questions as well as we get through here. So I actually find that I give a number of presentations, and some of them are tax, business organizations. I find people actually like this one the most, which was kind of surprising to me. But so I guess we'll see how you guys react as well. But in general, tonight we're going to just talk about trust, the benefits of trust, and the importance of holding real estate, and a few case studies, and then we'll open it for Q&A. But as I mentioned, feel free to stop me and ask questions as we go along here. Okay, so who knows what a trust is? Can anybody answer that question? It's up on the screen, so you kind of have a cheat here. But like, does anybody have any idea or like simple explanation? Yeah.
So like when someone passes away, they trust somebody or they're like designee to act on their behalf on getting rid of their assets.
Yeah, that's correct. Like from a general perspective, a trust is an estate planning device, right? Or that's what most people know it as. So when you pass or you become incapacitated, you already have this plan in place where you appointed a third party. Maybe it's your living spouse, or if both of you have now passed or become incapacitated, a third party such as your children, or even like a corporate trustee to step in, manage your assets, and provide for your beneficiaries, which are generally your kids, right? But legally speaking, it's a fiduciary relationship. So what that means is that you're going to sign what is essentially a contract giving somebody powers over, it could be yourself, it could be a third party, over the assets you put in trust. Essentially, I'm entrusting you with my assets to manage them on my behalf. You could be entrusting yourself, but it is a legal relationship that's defined by California law. The easiest way to think about it is kind of in the term of a contract, right? So to have a trust, or for it to be effective, there are a number of requirements, but there's generally three parties, right? So one is the trustor or the settlor. That's the person who's actually going to fund the trust and create it, right? So if I wanted to create one, I'm putting my assets in it, I'm technically the settlor. Second is the trustee. So this is the person you're giving power over the assets in the trust, right? So generally speaking, a revocable trust using an estate planning device, I'm going to make myself the trustee of my own trust because I'm going to appoint the powers of myself to continue to manage and utilize my own assets. But it doesn't have to be like that. It can be your brother, it could be your children, it could be an independent party that you appoint as your trustee. Generally, what happens is you appoint yourself, and then once you become incapacitated or you die, that you appoint a successor trustee who steps in and manages those assets. Third is the beneficiary, right? This is the person you kind of want to be, right? So that you have the benefits of all the assets and the income thereof. Again, it's usually yourself in most cases for revocable trust. If I set up one, I'm going to be the settlor, I'm going to be the trustee, and I'm going to be the beneficiary of all my own assets. However, once you pass, that's where you name your successor beneficiaries, which in most cases is your kids, if you want to provide for another family member, or even like a charity, right? It could be anybody that you designate. But to have a trust, you have to have those three parties. And then there's the fourth requirement, right? You actually have to fund it with the assets, right? If the assets don't go in, then the whole thing doesn't work, right? So when we're talking about trusts, there's two general types. The ones that you guys are probably familiar with or would understand is a revocable trust. So, and there's also another one called an irrevocable trust, and the difference is really in the name. So a revocable trust is one that you can amend, change assets in or out, so fund or pull out, change the beneficiaries, the powers of the trustees, change the trustees. You essentially do with it as you will. So a revocable trust, and people kind of think, and we'll talk about this a little bit later, people think trusts provide asset protection. Well, that's not the case, right? It's for a very specific trust. A revocable trust is one that provides no asset protection and is really just an estate planning vehicle. And if you think about it, you have so much control and power over those assets. The law is like, what's the difference between you and a trust, right? You're the alter ego of the trust. So they say no asset protection. Also for tax purposes, revocable trusts are disregarded. You don't have to file a separate tax return for your revocable trust because you are essentially the owner and you manage all those assets. The tax law says, hey, no, there's no difference. You're reporting all the income and expenses of those assets therein directly on your personal return. All right, so an irrevocable trust. Again, the difference is really in the name. Irrevocable trust is once it's created, it's executed, and it's funded, you can't change it, right? It's supposed to be irrevocable or you can't be amended. So that means the beneficiaries you designate, the trustees you designate will not change. However, in the context of asset protection, irrevocable trusts are generally respected. And this depends by state, right? Because there's such a separation between you and the trust itself and how it's managed, generally there are some sorts of asset protection. However, what I will say is if I create an irrevocable trust, knowing I'm about to get sued, and I put my assets in there so somebody can't reach them, law is going to say, no, you did this in advance of getting sued and knowing that you're going to have some sort of liability. So in those situations, that will only work if you go to Nevada, Alaska, or South Dakota. So you have to go somewhere else. California, they're going to say, no, you're still, your assets could still be collected upon. All right, and one note I always like to keep here is, right, so most people think trusts have to be in writing. That's not true. Underneath California law, they can be in writing or through an express agreement. So if I give Sean my car here while I go on vacation, say I'm going to entrust you with my car to watch over it while I'm gone for a few months, theoretically, there's actually a trust created. It's called an express trust. And now there's a fiduciary relationship on them. That's more of like a law school, case law type thing that you see these weird nuance arguments. That's like a very slim cases, but something to be aware of because it does not need to be signed. However, go ahead.
Irrevocable, upon death, can a revocable trust trigger an irrevocable trust?
Very, very good question. Yeah. So what happens is that during your lifetime, your trust is revocable. But once you pass on, that trust, if you're the settlor, now becomes irrevocable. And if you think about it, the way the law operates, they want your willful or your like estate planning intents, so to provide for your beneficiaries to be put in place and to not be changed. So if I had like named my kids as the beneficiaries of my trust, I wouldn't want them or somebody else to come and have the change or have the ability to change the terms of who the beneficiary is or is not. And what I will also say, most estate planners will set up a trust in an A-B fashion, so between spouse and spouse. So if one spouse dies, only half of the trust becomes irrevocable, and the other half that's remaining for the surviving spouse still remains revocable. And if you think about it, because one spouse died, the second one could go on and get married again and have new kids and could fall out of relationships with prior kids or prior people the prior spouse provided for, right? So the law and trusts are generally set up in that fashion, but there's ways to get around that if you so choose to. Okay. So now that you guys know what trusts are, we're going to talk about the benefits of it. And if there's one thing to take away from tonight, it's this first one, avoiding probate. So if you guys know what probate is, or if you guys had to deal with it before, you know it's expensive and it's very long and it's very public. So if you do not have a trust, and let's say you only have a will in place, or you don't even have a will, and you die, your kids or a representative has to go and file a petition with probate court and say that, my parents have died, here's all their assets, and here's how they should be distributed. So if there's a will, it will tell the court how to distribute all the assets to their kids. If there's no will, you have to rely upon California statutory law to say how assets are distributed, right? And it's very, like I said, it's very public. So everything you submit to the court becomes public record, which includes all your assets, right? Secondarily, it's really expensive because the way probate works, those attorneys are paid statutory fees based upon the fair market value of the estate. So when we're thinking about that, and I always bring up this example, like $1 million house in Mission Viejo, just to take a single asset estate, if that's all that person had, would be about $16,000, which is a lot. And then if that attorney is involved in the sale of the home or some sort of dispute, it could automatically double. So, and here in Southern California, a 2-bedroom house now is worth over $1 million, which is good for a lot of people. But, at the same time, it's something they need to think about when it comes to this. And then third is the length of time, right? So this is the worst part, I think, about probate, especially with COVID. You guys know things are impacted, right? All these government agencies are already kind of slow. They've gotten slower. Their workforce is now starting to ramp up. But to take an estate through probate, what I've seen traditionally over the past 2 years, it's about 9 to 12 months. So that means your assets are sitting in limbo. Nobody can actually step in and sell those assets, distribute them to the beneficiaries for 9 to 12 months. And this is something to really think about if you have kids or family members that have certain type of mental deficiencies or physical deficiencies, and they can't fend for themselves. They won't be able to take care of themselves. There's nobody who automatically steps in to protect them, right? So maybe they have family members who can do that, but that's not the case all the time as well. So the number one thing about trusts is that if you have one in place and you have assets in it, the law views that as an exception to probate. So powers have already been granted to somebody else, i.e. the trustee, to step in and start managing the control of those assets. So that means they can step in immediately, start distributing out the assets to the beneficiaries or managing on their behalf. There's no wait time. So, go ahead.
I have a question for you. So in my 40s, let's say I do a trust today.
Yep.
And then, my assets increase and hopefully I'll have a lot more by the time I'm dead.
Yep.
If I do a trust today and then my net worth changes, do I need to do a new
trust?
So then the whatever else is gained between now and then is included in this trust.
So no, theoretically, trusts are set up to plan for the future like that. So what I would say, the reason why you might change your trust, it's not because of avoiding probate or things along those lines. It might be for an estate tax consequence, right? So if somebody if a single person has more than $11 million in assets, married couple 22 million, when they die, that excess is subject to a 40% flat tax. It's a death tax. That amount is supposed to cut in half at the end of 2025. So you plan on living past 2025. That means if a married couple has more than $11 million in assets, the excess is taxed at 40%. Single person, more than 5 million, 5.5, subject to 40% tax. So you might change your trust so that you could set up for certain estate planning vehicles that will reduce that, right? Or get assets out of your estate. But a trust, so long as California law doesn't change all that much, So long as the trust is in place and you actually title all your assets appropriately in the name of the trust, then you'll be okay, right? It's just very important that you do that. And this is always a stat I like to bring up, but it's about 80 to 85% of trusts out there are not properly funded. So what happens when that's the case, where assets are put inside there? That means they have to go through probate. So you've set up this whole like estate plan vehicle for essentially no reason, right? And the reason I think it happens is because the rise of the internet, LegalZoom, Rocket Forms, all these things that are out there, people will actually go on there to fill out the trust, put in their name, but nobody ever tells them how to fund it. Like, how do you actually put your property in the name of the trust, right? You actually have to prepare a new deed and a preliminary change of ownership report and file that with the county to tell them. And that costs money as well. So people don't think about that. And if that's not the case, you have to go through probate for those additional assets as well. Okay. So that's the number one thing. Avoid probate. That's why these things are so beneficial.
Sorry,
Yes.
I'm gonna have a bunch of questions. Sorry.
Yeah.
Does that change your tax bracket for your property once you change temporary ownership of your property to put it in the name of the trust?
So it depends on if it's revocable or irrevocable. If it's a revocable trust, there's, for tax purposes, the thing is disregarded. So the tax law says that thing's not even there, and it's like you own it directly, right? If it's irrevocable, the trust is viewed as a separate tax-paying entity. Trusts get in the top marginal tax bracket at about $12,000 for federal tax purposes. So if you have a irrevocable trust that holds rental property, likely you're going to be paying 37% top marginal tax bracket on that. Whereas like for if it's held in a revocable trust or your personal name, the top marginal tax bracket doesn't hit till about $400K, and that's always changing year by year as well. So hopefully that answered your question. Okay, so beyond probate are these next two, and they kind of go hand in hand. It's property management and financial management. So for both of them, the benefit is that if you have a trustee or a successor trustee, it can account for situations that you have not really expected, right? So say I'm driving along, I have a successor trustee, that's my kids, or a corporate trustee. I get a car accident. I can't fend for myself anymore. Maybe now I'm a vegetable or I can't work. Those persons can step in, automatically take over my bank accounts if I so choose them to, or if it's approved by a doctor, right? And actually start investing on my behalf, paying my bills, and managing my life if I can't do that. So also what you'll see this be used for is people will set up certain types of trusts, kind of like the irrevocable one that we talked about for tax planning purposes, and they'll actually put assets in there. And they'll appoint a corporate trustee or even a property manager, if it's a piece of real estate, to step in and manage that property on their behalf, right? And in those cases, because there's such a separation of the person who funded it and the control, there's a lot of asset protection that goes into it. And then they also limit their beneficiaries from being able to access and control it, because theoretically, you're not going to want to give, like, I wouldn't give me at 21 years old a parcel of property to manage. Like, I didn't even know what I was doing back then. So that's like kind of the scenario there. So it's very beneficial in those contexts. All right. So some other items that we can use trust for, and I kind of just alluded to this, but is lifetime gifting. So this is kind of a tax planning strategy, or if you want to provide for your kids now, right? So generally speaking, in that same scenario I was talking about, I wouldn't want to give myself at a young age a large sum of money. And so what you could do is you could set up these irrevocable trusts, put assets in there, provide for whoever you want during your lifetime, and they can't actually access it because now you've appointed a third-party trustee. It's also a way to give assets out of your estate in case you're going to be subject to that estate tax as well. So what a lot of people are doing right now is they're setting up irrevocable trusts and they're gifting a lot of assets into it. I kind of talked about the estate tax exclusion earlier. There's this net, right? It's supposed to drop from 11 million a person to about 5.5 million a person right now. So people who think they're going to be above the 5.5 million figure after 2025, they're taking advantage of the net that's currently out there. So that means they can gift up to 5.5 million assets out of their estate and to their kids now into one of these trusts and avoid the estate tax should they be subject to it at a later date. And I'm sure you guys have seen this with the Biden administration, or maybe you guys haven't read the BBB. It's kind of boring after a while, but there was a point in time where they were thinking about getting rid of the estate tax exemption. So it was either get rid of it or reduce it to $1 million or $3 million. So that means any assets in excess of that figure get subject to 40% tax when you die, which, again, you live in Southern California, you own one house, you're above that, and your kids are left with that burden at the same time, right? So a lot of people are trying to take advantage of this large net, and I'd say it's kind of like one of a lifetime opportunity to get assets out of their state and provide for their kids now. All right, the next thing trusts are used for, taxes. We just kind of talked about that with lifetime gifts, but when you're thinking of taxes, trusts can be used for like 3 of the 4 pillars. I think of tax in 3 or 4 pillars, right? So there's income tax, gifted estate tax, property tax, and then sales and use tax as well. Trusts don't really work for sales and use tax unless you're investing in some sort of like specialty automobile and transferring around the country. So for income tax purposes, what you could do is, we talked about this, is if you set up an irrevocable trust and you're already in a high tax bracket, there's ways to shift assets into that trust for the benefit of your kids, so it's at a lower marginal tax rate. But as we talked about, it's easy to get to that top rate. So a lot of people don't use it for that. What you actually see is people use it for state tax purposes. So to avoid California state income tax. There's certain types of irrevocable trust you can set up in a 0 income tax state like Nevada, Alaska, Delaware, South Dakota, where you can transfer certain types of intangible property, so stocks, bonds, ownerships of companies, and sell it thereunder. If you do it appropriately, it will not be subject to California tax, right? So it's called incomplete non-grantor trust. Something that is a little, I'd say California is trying to combat, New York is as well, but that's what you've seen a big rise in as of late for income tax purposes. For estate tax, we kind of talked about the lifetime gifting, getting assets out of your state so you fall below the exemption. And the final one here is property tax. So do you guys deal with California Prop 19 earlier this year? Didn't you guys kind of have like an experience with that? So essentially what happened, and it looked very nice on the ballot that they're going to increase revenue for wildfire victims and things along those lines. But what they did is they got rid of the property tax reassessment exemption for parent to child or grandparent to grandchild transfers. So beforehand, if somebody died and you're in your house transferred to your kids, could be a house, could be a rental property transfer to your kids, California wouldn't reassess your property for property tax purposes. It would stay at the same basis. Now they got rid of it or significantly limited it in those situations. So the only way that you can avoid a reassessment when your principal home, your principal residence go to your kids, is if they actually move into it as their own principal residence. I don't know many kids jumping at the wind there to move in their parents' house once they've passed away, right? I just don't see that. So that kind of gets rid of that property because now it's going to be reassessed at fair market value. And maybe they can't afford it anymore. And then, go ahead.
So if a child moves into a deceased parent's home upon their death, what's the limit, or rather the time frame that they're required to occupy the properties for it to be considered theirs to avoid the tax?
So you'd have to move within a year because you actually have to claim it within a year. And then, so California regulations haven't said that yet. But I would assume the moment they move it out of the house as their own principal residence, it would. Theoretically, I mean, how's a property assessor going to find out? I don't know. But there's more regulations to come on that because Prop 19 was passed. It just was effective February 16th, or almost just a year ago now. And so they're still putting out regulations. Also, with rental properties or any other properties besides your principal residence, they used to be able to transfer to your kids at least $1 million of value to your kids without a property tax reassessment. Now, any sort of transfer gets automatically reassessed to fair market value. So you can't transfer anything besides your principal residence to your kids without incurring a property tax reassessment. So right before February 16th last year, there's all these very smart estate planners who are going through and setting up California Prop 19 trusts, which they could contribute these assets to. And it was mainly, rental properties, vacation homes for their kids. And if you did it appropriately, you could avoid a reassessment and fall underneath the old law, right? I've also seen this too. I've had to take a few people through this, are just assessments from the county assessor underneath the new law when it should have been underneath the old law. They're so inundated right now trying to implement this. I know I'm kind of going on a tangent of Prop 19, so I apologize. But if you get a notice, like they're probably reassessing it incorrectly. So you probably want to challenge it. I've taken a few people through it and been successful. It's just something that they're so overburdened with. They've just been sending out reassessments kind of like on a flat wide basis without any sort of like detail or nuance. All right. So beyond that, trust can be used for tax purposes as well. But one thing people always want to talk about is asset protection. So you guys have probably thought about this. I like to always bring up the quintessential case is O.J. Simpson. So people always wonder, like, how did he keep his money, after losing that civil suit, right? What he did beforehand is he set up a self-settled spendthrift asset protection trust in Nevada where he contributed most of his assets to. And by way of that, so long as it's set up appropriately, creditors can't reach those assets. And it can even make distributions to him for his health, wellness, maintenance, education without creditors reaching that as well. So there's ways to set up trusts, and they generally have to be irrevocable trusts, which you have limited powers of control over to put your assets in and avoid having your creditors obtain it. So again, asset protection is not going to work in the case of a revocable trust. If you can change the assets and you manage them, most law is going to say, no, you can't do this. Most of the times, it has to be an irrevocable trust where you're not the trustee of it, and you have a third party managing it as well. And the most favorable states, I keep bringing them up, are Nevada, Delaware, South Dakota, and Alaska. So they allow you to set up your own spendthrift trust for asset protection purposes and kind of get away with it. It's kind of crazy. There's ways to challenge it, but it's very hard to get around it. I also see, because I do a lot of international tax as well, I see a lot of people setting up offshore trusts as well. Those are a little sketchy. I'd say probably you don't want to do that unless you have a good contact in those countries. But I've seen people do it, and they get away with a lot because these other countries, like Cyprus is one, you can't find an attorney there to represent you because they all have a conflict of interest with the other trust companies that they work with. So it's almost impossible to sue anybody. Doesn't mean they can't reach it. They can't just ever initiate a suit. And then, it just becomes very costly still to defend yourself. But I thought I'd leave you with that as well. Okay.
Question for you. Is crypto considered an asset this day and age?
Yes, it is. So the IRS defined it as property in 2014. So, and then just underneath the law, it is, for legal liability law, I think it would just kind of be considered the same. It's not technically currency. It is a form of property. So, yeah. All right. So now we've kind of talked about conceptually what trusts are, what their benefits are. I always find it's instructive to kind of go through a case study using a trust and not using a trust as well. So, all right. In this first scenario, we're going to have Harry and Wilma, right? Husband and wife, who are both the age of 65 and they own various properties, right? Primary residence worth $1 million, a vacation home worth $500,000, and 2 investment properties worth about $550,000 in total. And then they have 3 kids, right? A daughter, Donna, who's age 30 with a full-time job. You have Sean, the son, age 24, still in graduate school. And then you have the minor son, Matt, who has a full-time disability has a disability that requires full-time care. All right, so in 2020, Harry and Wilma put all their assets inside a revocable trust for the benefit of their kids. They appoint themselves as the first line trustees, but in case of their passing, they're going to appoint a corporate trustee, which is a bank or a trust company to come in and manage the assets in their trust or distribute it as they so choose to. All right, so, and the trust has a few provisions here, right? So the total estate is to be distributed equally amongst the kids upon their passing. If upon their passing, Donna or Sean, these are the ones without the disability, have not reached the age of 30 and don't have a full-time job, they want their share of the assets to be held in trust until they meet those requirements. So this is something I don't know if I touched upon earlier, but you have a lot of flexibility in the trust as to how you want them to be distributed and manage it after your passing. So you could say, I want my assets held in trust till my kids reach the age of 30, then they could take it. I have a client whose parents set up one that wouldn't make a full distribution to them until they're the age of 70, which is a long time. She had some mental problems, and she's a little kooky, but it was pretty crazy because she had just reached 70 and she was having troubles getting it out. So just think about it. There's a lot of flexibility with this. All right. So then for the minor son, Matt, who has a disability, Harry and Wilma specify that as 1/3 share. will be held and managed for his life, right? So that's the benefit of these trusts, right? Especially in this case, when you have a kid that has disability like this, you can make sure that they're provided for your life. And generally speaking, you're going to appoint a sibling to manage it, but you want to appoint a corporate trustee, somebody who's going to immediately step in, appoint fiduciaries or even medical professionals to come in, right? All right. And then, of course, in 2021, Harry and Wilma passed away unexpectedly. Yes.
So what happens when this child with the disabilities that requires full-time care?
Yep.
Has benefits for life, and then after 2 years passes away? What happens to the remaining share of the trust?
So generally, the trust would be set up to say that if he has kids, it would go as kids. That's not likely to happen, right? So it would probably go back to the other remaining siblings or their issue as well.
Would that go to probate in order for it to go back to them?
No, because
default to them because it's in the trust.
that's right. Because it's already in the trust and dictated, it would automatically go to them and not have to go through probate. So good question, though. Okay, so what happens? What's the benefit of the trust now that they've had it in place? The number one thing is that they avoid probate. So really, the best thing is for Matt, the minor son. We kind of talked about this. Immediately, the corporate trustee steps in, can start managing and providing for their minor son with a disability. It doesn't have to go through a formal court process that's going to take 9 to 12 months, right? So that's the number one thing, is avoiding probate. And then kind of coinciding with that is this property and financial management. So we talked about the restrictions on the distribution. So the first kid, Donna, she reached the age of 30, right? And she has a full-time job. So according to the terms of the trust, she gets her 1/3 share right off the bat, no restrictions. For Sean, right? He's still 24. He's in graduate school. He hasn't met all the requirements. So his share is actually going to be held in trust and managed by the corporate trustee. That corporate trustee is likely instructed to provide for his health, wellness, maintenance, and education. You can also put different standards in there, but that's what you generally see. And that means the corporate trustee can pay for his school on his behalf, can pay for all his rent, kind of just take care of his life. And all Sean has to really do is submit his expenses. And so long as the trustee doesn't find them to be unreasonable or outside what the terms of the trust say, the trustee will automatically provide for him. And then again, we talked about this for Matt, the kid with the disability. The corporate trustee steps in, manages his 1/3 share for the rest of his life, right? And gets to provide for his disability. And a lot of times, if there are siblings, they're probably willing to step up to the plate and help out. But that's just not the case with every single family. There's a lot of feuding families out there who don't have good relationships. So luckily in this, for this scenario, he has somebody to provide for him, but that's not always the case.
On this scenario, so like, let's say that the, like Nick was saying, is the one son passes away unexpectedly, he doesn't have any children, the funds go back to the other two. Let's say that they didn't have any children and there was excess funds at the time of their passing.
Yeah.
So then, where does that money then end up?
Yeah. So what happens is there's usually a provision in there that says it goes to their heirs as defined in California. I forget what the probate code section. Okay. So it would follow essentially what is intestacy law. So what happens if you die without a will or a trust or estate? Right. So if it's not specifically provided for, the way it would go down to their children. If they didn't have any children, it goes back up to their grandparents if they have any grandparents. If not, then it goes down to their siblings as well. If they have no siblings, it goes to their kids, and it kind of goes up and down. Yeah, and then if there's no possible family member, last thing, it reverts to the state. So that's what happens. So eventually, that would take a long time, but that's the last thing that could happen as well. So
you put a provision in there I wanted to go to a charity.
That's correct. Yeah, so you can put a provision there saying I want this to go to charity instead of going to the state as well. So. Okay, so the next thing, we talked about this kind of at the top of the class, right? So the trust transforms from revocable to irrevocable, right? So that means when they both pass, the provisions inside the trust can't be amended. Donna can't come back and try to get Matt's 1/3 share. Sean can't try to say, I want my distributions early. They can't get the trustee kicked out except for limited situations when there's fraud, which does happen. And so that means, these kids are automatically provided for, and that can't be changed. And then the final thing to talk about here is asset protection. So we talked about this. Revocable trusts no good at asset protection. Irrevocable trust, great for asset protection. Now, because it's irrevocable and there's likely this clause called a spendthrift clause inside there, that means if the kids, Matt or Sean, have creditors, they can't go and reach the assets that are in trust and held for their benefits. That would even mean those creditors can't receive the proceeds that are distributed for limited items such as health, wellness, maintenance, and education, because that's defined as an exception underneath the California Code. If there's distributions or excess distributions outside of that, then creditors could start to reach it. So you can think of Sean, he's young, he's still in school, maybe he gets in a car accident, right? If there's a judgment against him for that, his 1/3 share is still protected. Now, eventually he's going to be 30 and get a full-time job, or I don't know, maybe not.
40.
Yeah, 40, yeah. And so once that happens, he gets all the assets, right? That creditor can get it. But really, again, this is very important for Matt, right? Matt is disabled. He'll likely never get a full-time job. There will always be held in trust. And what you actually see, it's kind of it's like Medicare, Medi-Cal planning. I don't really specialize in this area, but there are these special trusts that are set up for people who are disabled, such that if they run up certain types of medical bills that are not covered by the trust, or the trust will not pay because they don't have enough sufficient funds to cover that, as well as rent and everything else, they can't collect against that, right? And so he can kind of still receive medical treatment while, unfortunately racking up bills, but he won't be left out to dry at the same time. So
In irrevocable trust, like if I'm the beneficiary and I get a divorce, can that creditor come after me?
So generally speaking, no. So that's a good thing to talk about. So what happens is that, we all live in a community property state, which means half of what I have is half of what she has. We own everything together by default. However, there's an exception for inheritances or gifts. If you receive something via an inheritance or a gift, it's technically separate property, right? So if you leave it in that trust and you never take it out, likely it's not going to be subject to the divorce. The only time this starts to get a little funky is if you have a distribution out of there, and let's say it's a parcel of property, it actually comes out of the trust, and you start using the proceeds for the benefit of the community. Some case law that comes out there and says now it might be community property. So in those situations, I would say, if you think you're going to get divorced, leave your stuff inside the trust. So, okay.
Question, what if you have a trust together and then you get divorced?
So everything inside the trust that you create together is generally community property as well. So the only way that you can avoid that is if someone else is gifting you the assets through a trust that they create out for your benefit.
Question. I heard, before, if you own the house and when you sick, when you get the Medicare or Medi-Cal, and then the bill, let's say like a $3.5 million, you can lend on the property. But if you put on the trust, you cannot lend it. That's true.
So what you can do is, and this is for special types of like irrevocable trust. So let's say, you're starting to get older, you're going to have to go on Medi-Cal, Medicare, you're going to have a lot of like medical expenses. There's certain types of trusts that you could set up that are irrevocable, where you could put your house in it and you can leave your power or leave the ability for yourself to live on it or use it for the rest of your life. It still qualifies an exception to qualifying for Medicare and Medi-Cal. And if you appoint a third party to actually manage that trust on your behalf, it's no longer your house. It is your house, but now you have somebody else who's actually managing it. You can live in it. Then that will generally be respected and your creditors won't be able to reach it. So, yes.
What about selling property that's a part of the trust? How does that work?
So generally speaking, there's a specific way to hold title to assets in the trust. So if I set up,
Assuming it's an irrevocable trust.
assuming it's irrevocable.
Yes.
So essentially if you're the beneficiary, you don't get to make that call, right? It's the trustee. So the trustee is generally provided a ton of flexibility and discretion over the assets inside the trust. So let's say that you're the beneficiary of an irrevocable trust and all the assets are supposed to be held for your benefit. If there's no provision saying otherwise, that trustee can go in there and liquidate everything and reinvest it in stocks and bonds if they find that to be better for you. They always have to provide for your benefit and do what's in your best interest, but I find that's not the case. Like there's some estate litigation where trustees are actually protecting their butt more than they're actually like looking for the best interest of the beneficiary as well. So theory they're supposed to, but in practicality it doesn't always happen that way because they're trying not to get sued themselves. So,
But like in Nick's point though, like, so we as agents see this all the time, that there's a living trust, and then we just sign a form saying that they are the trustee
Yep.
selling the property, and they are the signers of the living trust. And then you can sell homes and then move them into trust back and forth. We do that all day long.
yes, yeah, you could totally do that. Yeah, so the way you hold like assets in a trust, it's supposed to be your name as trustee of the Alton Living Trust or whatever it is, and that's how you're supposed to hold assets. And you sign like on title. So that's why you'll see that on deeds. And there's certain types of certifications. They have to essentially certify they have the power to do that. So, okay. Okay, so now it's the same example, but what happens if we don't use a trust, right? So there's 3 kids. Harry and Wilma have multiple assets inside there, but now they just have a will, and this is how they're going to provide for their kids, right? So the first thing is that after they die in 2021, they're going to go into probate, right? So we talked about this. This is what you want to avoid in this type of situation. The probate fees. This is why I gave the relative values of the home. So let's say they have an estate worth about $2.025 million. Off the bat, the attorney's gets statutory fees. This is statutory. Doesn't matter how many hours they spend. They can spend 1 hour, and they're going to get $33,000. If they're involved in the sale of the houses, generally speaking, these are called extraordinary. They get a bump up for extraordinary actions or fees, and it could be doubled up to $66,000, which for some probate is not something that's hard. And, it's just a matter of like paper filing. So I would say that's a pretty absurd fee. So and then their kids have to bear that as well. And then second off is the probate timing, right? We talked about this right now, with COVID. I've been seeing 9 to 12 months. This is a little bit earlier, 7 to 12 months for some like simpler estates. But the problem really is if they have to go through that, that means nobody could step into the assets to manage for Matt's disability, right? They're sitting in limbo. They're technically not the owners of it. They have to wait for the court to approve them to be the owners before they can actually go in and manage the assets. Yes.
What was the time frame before the pandemic?
You would see probably about 6 months, something like that. 6, 8 months. Obviously in super complex probate cases, it could take years. But for simple ones where it's just asset or two, it's easy. Yes.
And in comparison to those fees, how much does it cost to set up a trust?
Oh, good point. So setting up a trust, simple estate plan, about $1,500 to $2,000, and then on the back end, if the trustee is competent, they don't really need to have an attorney come in. Maybe they want to have an attorney come in. It's about another $1,500 to $2,000 to have an attorney come in and help administer the estate, assuming it's relatively simple. Now, if you have like 30 assets and all these investment accounts and all the stuff like that, right? What's that?
And crypto?
And crypto. Yeah, and crypto as well. Yeah, exactly. Then it might be a little bit more expensive than that. But, just generally speaking, it's significantly cheaper to implement a trust than to have your estate go through probate. So, all right. So that's really go ahead. Yeah.
So sometimes you looking on the house on the market and the house on probate. How come the agent try not to get the customer by a probate sale? Why? Because more complicated or what?
Yeah, so because you have to get the court to approve the sale as well. So generally speaking, in probate, people are just trying to liquidate the estate and distribute it out, right? So that's why you might see it being a little bit cheaper on there, but that's not always the case. Like I will see, especially now times in rising prices, you're going to see probate attorneys try to get the best offer that they can. And that's generally through like an auction. That's what you hear like at a probate sale as well. So we'll start with the price, generally fair market value, or maybe even a little bit less. And then nowadays the auction prices are starting to get above that, kind of like what you're seeing with all the bidding wars here in Southern California. So hopefully that answered your question.
So
Okay.
On the probate sale, probably no guarantee, not so like as or something, right?
Yeah, and that's part of it. So like essentially if you're buying it from an estate, like there's no repercussion. Who are you going to sue once the estate is done and distributed, right? So that's why you might see it be a little bit cheaper from the get-go because it's bought as is, and the person who's selling it doesn't have knowledge of like material defects. So I say material defects because you have to disclose those in certain types of disclosure statements when you're buying a house, if you know about it, right? And the property owners are dead. They're the ones with the most amount of knowledge. So like, how's a probate attorney who's never even visited the property be able to tell you about those as well? So, yep.
So when we see houses that are, it's a probate sale, the seller's a probate, so it has to go to the court and stuff. So what is the process? If we put an offer, who does that go to? Does that go to the attorney and then it has to go to the court for approval? Or
Correct.
how long does that process take you to estimate?
So I've seen, so it just depends on how, so there'll be like an auction that's set, right? So you'll actually have to submit offers like beforehand. And then there's kind of like a formal hearing on the actual price, and people can submit more offers right beforehand, or I think even in some cases during the probate sale. Once there's a price that's approved by the attorney, the probate attorney submits that to the court for approval. Then the court will actually approve the sale. So that's kind of like the general process. So, I mean, what I've seen, it could take a number of months just because trying to get things through probate and they're so backed up, you just have to schedule hearings with the court, and they just schedule things out there maybe 2, 3, 4 months out from now. And that's just kind of the general trend. So that's why you might see it take a little bit longer for a trustee, or I'm sorry, for a probate attorney to actually take a house through a probate sale. So
A few months.
yes, yeah, that's what I would experience. Yeah.
If
Yes.
something's in probate and like, let's say a piece of property, $1 million value, but there's a $500,000 loan and it's in probate and there's nobody paying that lender, is it protected from the lender closing on it while it's going through the probate so that equity is still captured?
Yeah. So generally there's a stay during probate for a certain period of time, but after a while that stay will come undone. And then the trustee or the probate attorney, the one who's in there, generally has to get approval of the court to liquidate assets so they could pay those types of debts on it as well. So generally speaking, there's a temporary stay, but it doesn't last for forever. So,
Okay.
yeah. And what I will say, it's like the lender will generally file a suit in probate court to get them to pay as well. They'll try to compel payment. So then it adds to the length of the probate as well, because the probate attorney will push it off.
Right, but if everything's an asset and it needs to be sold in order to pay, then
Yeah.
that's kind of like it's stuck.
Yeah.
And
Yeah.
then one other thing, so when you're talking about these official trustees that aren't family, what would you say when you're looking for a trustee that's going to be a third party, somebody that's going to handle these? I mean, like what type of companies or what type of background is this person qualify?
Yeah, so there's just specific trust companies. So all they do is they manage trusts, or they're appointed as trustee of these types of investment trusts. So there's like some of the big ones are like Icon Trust, and they're generally based in Nevada. I'll be honest, because Nevada is such a big trust state. So you see like Nevada Premier Trust, and then on top of that, I'd say the most common one that I see people use are like large banks, corporate trustee services. So you can appoint like Chase, you can appoint like Wells Fargo, or there other corporate divisions or trustee divisions to actually step in and manage it on your behalf, because you might already have accounts and assets with them as well. So
what type of fees would be associated with, like, roughly?
So it depends, because some of them do flat fees per annual, and some of them do like asset underneath management fee, where they take a percentage of the value of the assets they're under. So, and each one is totally different. They may even have like weird hidden fees, such as like acquisition fees, disposition fees, things along those lines. So you really actually have to like read the agreement. And I would say, generally speaking, the more assets you have for them to manage, the cheaper the overall price in comparison it becomes as well, because they might charge like 1% on the first $1 million, but then they'll charge like 0.75% on the next million, and 0.5% on the next million. But also you might be able to find trustees who just do flat fee services where it's like $5 to $10 grand a year, and then just depending upon the level of involvement, that's how the fees will scale. So sorry to say, it depends. That's an attorney answer, but
When we set up a trust, do we need a corporate trustee to distribute the fund, or can my son or my daughter do that?
yes. So you can appoint your son or your daughter to step in as a successor trustee. So I find that most people will appoint their kids to step in and do that, but you can include a provision like, if my kid hasn't reached the age of 25, I want this bank to step in and do it. But if they have reached the age of 25, then they can actually take over it because they may just not think that they have like the wherewithal to do it appropriately before then. But yes, you can appoint your kids, you can appoint your brother or sister, whoever you so choose.
So
Yes.
you already covered this, but if you know, let's say you set up a trust in California and then you relocate to Arizona or Texas, does that trust transfer with you, or do you need to set up a new one in that new state?
So what I generally recommend is that you restate the trust underneath the state laws that you move to. However, I'll caveat it by saying that most states' trust law or how trusts are respected are pretty consistent. They're not all identical though, right? So it's like if you have a California trust in place, but you move to Texas, likely the trust and how it's supposed to be distributed will be respected, right? Because you have the trust, you have the three parties, it's been funded, you kind of met the basic requirements of it. But because each state's laws are a little different, I just recommend that you go and restate the trust underneath the laws of the state in which you primarily live. And so, like, because if you move to like a non-community property state, right, things might be differently treated underneath California law than they would be in Texas law underneath that trust as well. So
if you don't update it, is there a chance that it could go into probate if something happens before you do?
no, so it would. So that's only if the trust like doesn't comply or is not respected for that respective state's difference, which I haven't seen because generally the basic requirements are you list the three parties, it's funded, and that's pretty much it. That's really what you need more than anything else. And then if it's proven by writing, which is it's not required in California, but some states do require writing and for it to be notarized, you're generally going to be okay. And so that's why it should go through probate, but it's not the case in every single scenario. So
I have a question from someone on the live.
Oh.
What's the biggest mistake you see people make after setting up a trust?
they don't fund it. So so I kind of talked about this at the beginning, is most people will set up trusts, but 80 to 85% of trusts are not properly funded. So if you don't put assets inside the trust, then those assets pass through probate, right? But people will set up a trust and maybe they'll fund it initially, but then they'll go and buy more assets, but they don't keep up with that as well. So that means they'll buy like a second investment property, but they'll take it in their personal name. And that means if they do that, it's not underneath the trust. And if they die, it goes through probate as well. So that's the biggest mistake. Yeah.
So along those same lines is I set up a trust, I put my initial home into it, and then I buy a secondary home or something, and let's say that I then go and I take and I quit claim that into the trust,
Mhm.
but I don't physically put that piece of property onto the living trust. Is that still covered underneath that? Because when I had the living trust made, I didn't have that piece of property.
Yeah.
I did fund it properly.
Yeah, that's okay. Because for real property, the most important thing is how the title is listed on the deed and recorded, right?
Okay.
So for other properties, such as like personal property, vehicles, furnishing, jewelry, there's things that you can do, such as it's generally like a 1 to 2 piece of paper that said it's called a declaration of personal property, saying I'm transferring all my personal property located at my personal residence, maybe this vacation residence, so on and so forth, to be transferred in trust. And so long as that's executed and notarized as well, that's generally respected. And so that could even apply to like cars. So like theoretically, like if you buy a car, you don't have to buy it in the name of the trust, so long as you're specifying it in that notarized piece of paper I was telling you about. And then bank accounts is something as well. You need to actually go to your bank and have them retitle the name of the accounts and the name of the trust as well. However, what you don't want to do is you don't want to put like a retirement account in the name of a trust. So generally speaking, retirement accounts, because you've already appointed a beneficiary, if you guys have heard of like transfer on death accounts, it's essentially an exception to probate. So because you already have essentially what's a contract in place to provide a retirement account to your beneficiaries, there's no need for it to go through probate. So, and also if you put a retirement account in a trust, what happens is that it speeds up the required minimum distribution period. So generally speaking, you have 10, 15, 20 years after like your parents die or somebody that leaves your retirement account to pull out all that income. And generally speaking, it hasn't been taxed before, so now you're paying tax on it. However, if you put it in a trust, it speeds up that required minimum distribution amount to 5 years. So that means you're pulling out huge chunks of it and you're recognizing a lot of capital gains or income on that as well. So.
But if I had a 401k, you're saying you wouldn't want the beneficiary to be the trust?
Yeah, so you don't want, so you don't,
Be an individual.
yes, you want it to be an individual. So you don't want to put the trust as the owner of the actual 401k. You might not be able to do that anyways. But like, because there's also like solo 401ks that people could set up in the name of a trust. But also you don't want to put the trust as the beneficiaries as well. That's correct. So
What about life insurance?
So life insurance is a special item. So when I talk about life insurance, generally speaking, you can put the trust as the beneficiary. However, if you do that, so we're talking about the estate tax earlier, those proceeds, because they're in your trust, are subject to the estate tax. So like if you had like 3 houses here in Southern California, and then you have a life insurance policy of like $1 million, $2 million, likely you're going to be over that estate tax threshold. And so that amount gets subject to the 40% tax. What you can do is you can actually set up this thing called an ILIT, or an irrevocable life insurance trust, where it's held in an irrevocable trust managed by a corporate trustee. You're actually contributing the premiums into it every single year, and it provides for your kids as the beneficiaries. If you do that appropriately and you respect it, that life insurance policy falls out of your estate, is not subject to the estate tax. Also, life insurance proceeds are not subject to income tax. They're a windfall. So it's a special type of trust you see a lot of people do, and it's used a lot of time when people are going to be subject to the estate tax as well. So,
Well, like in that, like if something happened to me early on and I didn't want my daughter to have X amount of dollars when she's 18 years old, how
Yep.
would you protect that life insurance? I mean, would you say going into that irrevocable?
so depending,
Instead of it going into the trust, which would be outlined that she can have it when she's 70.
yeah. So the thing is, you could actually do it. You could put the same provisions in both of them as well. So it's like if it goes in your normal revocable trust, it would just follow those instructions. But same thing with the irrevocable trust. It could just sit inside there until she's 70. Depending on what your estate tax liability is, you may not want to do that because most of the time they're set up to pay the estate tax. You can't put that directly inside the trust language because that's like an exception, but that's generally the understanding for it. So, okay. All right. So, all right. Case study 2, we don't have a trust. We're now going through probate. We talked about that. So property and financial management, right? So here, because there's not a trust in place and they had a will and they didn't appoint a corporate trustee to step in, that means the kids are all going to receive direct, as soon as they get to probate, which is a long time, they're all going to receive directly their 1/3 shares in the estate. So there's no limitations. Donna was already get hers, but she's going to get it. Sean was supposed to wait a few more years until he had a full-time job. Now he's going to get his 1/3 share. He's still relatively young. And then you have Matt, who actually is the one who receives his 1/3 share. He's the one responsible for managing his own assets as well. And he has a full-time disability and likely cannot do that as well. Next one is asset protection. Again, since there's no trust for Sean or Matt, right, holding those assets, there's no asset protection. So that means if they have creditors, something goes wrong, especially with Matt, who could rack up medical bills from his disability, there's no protection and his creditors can reach it immediately. And that's it. That's a trust estate, yes.
What is the best way to store a trust? And what happened is, let's say, when we die and the lawyer died before us.
Yeah.
How do the kids know when we have a trust?
Yeah, so the best way to start a trust and actually make sure it's in place when you pass away. So, right, so you want to get it set up. You want to go and actually fund it. What you want to do is nowadays, and like for me, I keep all my copies of my client's trusts. I'll keep them in perpetuity in like an online server. They also, back in the day before they had online servers, they used to have like trust vaults. And so like they would actually give you the trust and like a card or an address where that attorney would go keep a copy for in perpetuity. I actually had a client that happened to, his mother passed away. There's supposed to be a will. I went to the place I was supposed to be at and it was no longer there. So so that's not bulletproof. But so that means the onus is really on you. You keep a couple copies, you keep them in like a safe box, a lockbox or something like that, and you let your kids know, because you don't necessarily have to go back to the same trustee to help administer the estate, your kids can go to, I'm not trustee, attorney. You can go to any attorney, and they can, so long as they're a probate, they know what they're doing. They can actually help your kids out as well. So hopefully I answer your question. Yeah.
To set up like a pretty basic trust, I mean, like, house, I have a wife, I have a child. What's a good rule of thumb of cost of what this all costs?
Yeah. So generally speaking, to set up, so if it's like you own one house, you have a couple bank accounts, what I generally see it costs about $1,500 to about $2,000, and that really depends on like recording fees and how many things you have to transfer. If you have a lot of assets and you have like a lot of real estate properties, it starts to get higher than that. And then if you want like a lot of like modifications on how your assets are to be held in trust and who's to be appointed where and how they're held for your kids, then it starts to get more complex too. And, so generally speaking, more assets, so more money, more problems. I guess that's the best way to put it. So, yeah, well, way cheaper than probate. The only time you might hit like $30,000 is if you're setting up a bunch of specialty trusts that are for like income tax or estate tax planning purposes. But a general revocable trust for estate planning purposes, you're probably, even in the most complex, probably not going to get past $3,000 to $3,500. But basic is about $1,500, so at its lowest. Yeah.
Inside of the trust, can you also, like if something happened to myself and my wife, and name what would happen to our children?
Yeah, so you can't. So what would happen is essentially you provide for a third party to actually take care of them and manage those assets on their behalf as well. You can
physically, like I'm like willing off my kids.
Yep.
Yeah.
Like who's going to take care of them?
Yeah.
Like,
So
I can say like I don't want him. I want him to go to this family member.
yeah, exactly. So what you could do is you could specify for that inside the trust as well. You can also set up separate documents like guardianship, because a lot of people don't have trust. So there's other documents you could put in place to provide for that as well. So, sorry, I got a few. Yes.
Just real quick. So once you have a trust, let's say you get a $1,500 trust, and then over the years you acquire more assets.
Yep.
And you add them to the trust. So every time you add something to the trust, does it cost you?
Not necessarily. So what I would say is that if you want it, you can always ask, like I can provide my clients with this as well as like a Word copy, because the way is there's the basic trust and then there's schedules that are put on the bottom, right? And so necessarily, so long as those papers are attached to the trust, there's a provision there that says that these are hereby incorporated. I generally recommend that you get those updated and re-acknowledge them, or just have them like re-execute in front of the notary so that you actually have it cemented that they're part of the trust. But necessarily those schedules don't have to be updated. Like for real property, the most important thing is that the actual deed says the trust is the owner more than anything else. And then for like personal property and stuff like that, so long as you have some of these other ancillary documents, it's not as necessary to update those items all the time. So.
And Nick, as far as like to your question, is like that's something that we do with a lot of clients. They have property, and then we're able to, with title, able to fund those through different documentation and get those reported to the county.
Yes. Yep. And then yes.
Question. Let's say we do a living trust a long time ago. Maybe attorney gone, died.
Yep.
A whole family vacation. Let's say the airplane crash. How the government know your trust, where the trust is?
Yeah. So that's the thing. It's like so if your attorney passed away, it requires some due diligence to try to find out if they had like a trust vault or a will vault where you can like pick up copies of it, because they may have had that in place, but some of them won't. And if you don't have copies of it, then unfortunately you're kind of SOL, because another thing you can do is what some people will want to do is they actually record their wills or their trusts with the county recorder. You actually put it on public file, so if something happens to you, you have a copy of it. It's an extra fee that some people don't want to do. And it's, if you keep it in a nice safe box or something like that, then you should be okay. Nowadays with technology, you can upload it on an online server, potentially keep it there for forever, and then also inform your family members of where that trust is. Now, if you can't get any of that, the only way that you can prove the terms of the trust is through a court filing and then actual affidavits or testimony or declarations to the court that this is what I read. You would have to have your kids say, I read the trust. This is how the trust provisions were and how it should be distributed. And then you have to prove it through a number of court actions, which becomes a he said, she said type of battle, which is a The only person that wins in that case is the attorney. So.
But in this gentleman's cases, like if the home was in a trust, then somebody would identify that there was a trust that existed.
Yep.
And if I had a safety deposit box at a bank, and then somebody would be able to reverse back, and then they would come across it.
Yes. Yeah, that's
Something like a safety deposit box at a bank would be a good spot
to keep it. Exactly.
And then what do you feel is the pro and con? I mean, like in showing your children the trust, is there any?
No, I actually think it's okay. I mean, I guess I've never read my own parents' trust, but like, yeah, they have one. They have one. Yeah, exactly. Yeah. Yeah. No. They got it done before I went to law school. So yeah. But I mean, here's the thing. You could show your kids a trust. Maybe it'll cause some family turmoil and strife if you're providing for one kid over the other. But I would say most of the time it's equal distributions. And then also what you can let them know is when you show them that trust, there's this thing called a no contest clause. So if they try to contest the amount that they're entitled to, they're automatically pulled out from inheriting anything within the terms of the trust. So it really prevents or deters people trying to litigate. But if you have little kids, are they going to know what that means? I don't think so. Yes.
If you have a business or an LLC, should you put that in the trust, or can you put that in the trust?
Yes. So there's a few things to think about when you actually own a business. So generally speaking, I would say yes, you want to put it inside the trust, because if it's not inside there, then it has to, those assets or the ownership interests have to pass through probate. Generally speaking, you also have to look at like the operating agreement or like the partnership agreement to make sure that there's no approvals required from like your partners or other owners as well. But if you do put it inside there and you pass away, your kids can step in as trustee and immediately start managing it as well. So generally, I would say yes, but it doesn't work all the time because there's businesses that have partners and they don't allow you to do that.
But if you're the sole owner, then
You should be okay. Yeah, exactly. Yep. Yes.
Do you offer free consultation?
Yes, I do. I offer free 15-minute consultations. So like if you have questions, I'm happy to set up a time to chat with you and kind of let you know about your situation and see how I can be of help. Thank you. Yeah. About 1,000. I'm just kidding. Yeah. Yeah. One per person, you know. It's not like you can set up another email address and get to me, right? So yeah. Okay. I mean, so that's all I got for you guys. So very nice to meet all of you. Thank you for having me. So, yeah, of course. And then I think Sean will send it out, but here's my contact information. I've got cards. So.
And we also put it inside the booklet as well.
Oh, pass. I didn't see that. Okay, nice.
Yeah.
Yeah.
This is for you.
Oh, thank you. Very cool.
Okay. Well, thanks so much, guys, for attending.
Yep.
And if you have any questions, Alton's email, and that's your office line, right?
Yes, that's my office line. So
Perfect.
it's connected to my cell phone, so I should be able to get it. Yeah.
That's right now.
Yeah.
How long does it take to set up a trust? We don't meet with you in person?
Yeah. So it depends. I will say this, it really depends on you, actually. So it's like, because I send you a questionnaire and then I need you to respond to everything and give me all the associated documents. I could see sometimes people are on the ball. They get it to me back in 2 or 3 days. And then it takes us about 2 to 3 weeks to get everything drawn up for you to approve it. And then we sit down with the notary once you're okay, and once you approve it, and we execute it. So I see general timeline 2 to 4 weeks, but sometimes it can take longer than that, just depending back and forth and complexity. So, yep. Yeah. Shoot, I've got time tomorrow. Actually, I'm pretty flexible tomorrow. So yeah, that's first for me. Yes.
So random question, can you include property so I own property abroad,
Yes.
real estate, can I include that in
In a trust.
here?
Yes. So theoretically, it will be respected from a U.S. Perspective, right? However, you also have to look into foreign country law as well to see if it's respected underneath their laws too. Because what happens is that just kind of like from state to state, they may have different requirements for you or your trustee to step in and do that. So when I've worked on like international trusts, you have to set up the provisions inside the trust so that they meet the requirements of the foreign country and of the U.S., right? So when I say that, it generally requires counsel of that foreign country as well, because we can create a combined trust document that respects both California law and then like UK law as well or something like that. So yeah, so it's possible, but it's expensive though. All right, thank you guys. Yeah. Oh yes, totally forgot about that. Yeah.
Good deal.
Yeah, thank you for having me again.
Yeah, absolutely. We had a couple people.